You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, audience. Today we have Mark Solomon joining us for a fantastic episode of the Subrogation Support Network podcast. Today we're going to be talking about the great state of Texas. Amazing place. Mark's wearing his cowboy hat and cowboy boots right now down there as we speak. Mark, how you doing?
Excellent. Thanks for having me on the show here, Ashton.
Beautiful. Well, hey, Mark, you've joined us a few times. The audience knows you well. If they work with MWL, they know that you are the managing partner and a shareholder here of our Texas office. Tell us a bit about yourself. Tell us what you're doing down there, managing the Texas team and making sure that Subro in the great state moves forward.
Yeah, so I originally grew up here in New Mexico, moved down to Austin to attend the University of Texas, Hook'em Horns. Did my undergrad here, moved to Houston for law school, and then worked in jobs out of law school, starting in subrogation. With my first job, moved over to a second job doing high volume subrogation practice as well. And then eventually took a job to move me and my family back up to Austin, about 11 years, running Farmers Insurance in-house subrogation law firm. Joined MWL roughly 6 years ago, and we've expanded the Texas office from just 2 attorneys when I started, now 7 attorneys and a full support staff with folks in Houston, down in the Valley, and then our main branch here in Austin. So we are on a upward trajectory of growth with the Texas office, and something that I plan on continuing to expand our footprint throughout the state as we continue to grow this office and increase our recoveries for subrogation, not only in Texas, but across the country and the Southwest, where we primarily handle cases.
And any excuse you give me to come down and eat some Texas barbecue, I will take. No question on that.
We have that down. There's no lack of good barbecue down here.
All right. So today, for the audience, background, I'm going to start doing a series where we go into some of the states where we handle a lot of workers' compensation subrogation. And we're going to have kind of a state-specific subro conversation where we're not going to necessarily go into the nuts and bolts of investigating claims, pursuing subrogation in general, but we're going to talk about the state-specific things. What is unique about, be it Texas or California, that you should be aware of as you're handling claims? And there are a lot of claims that we see down in Texas, given just the size, scope of that state. Right, Mark?
Yeah, correct. With just as many people that are moving here from across the country and companies that are relocating into the Texas kind of triangle, that'd be Dallas, Houston, Austin, San Antonio. We're just seeing a lot more claims come through our office. It's just a simple result of the population growth and more people being out and, returning to work and getting out and handling their jobs. So a lot of business down here to be had and a lot of claims that we handled.
Thanks, Mark. So tell me a bit about Texas in general. Put that professor hat on of yours and, tell the audience what's unique about Texas. What are some of the big takeaways that they should have as they continue to handle, or maybe they just start to handle claims in Texas in the work comp context?
So understand that Texas is a first dollar right of recovery under the Texas Labor Code. The lawmakers here have made it so that it's very business friendly, and that we don't have a made whole doctrine like other states. We've got a first dollar right of recovery for employers, and that encourages employers to get workers' compensation coverage for their employees. And I say encourage that because Texas is very unique in that we still allow employers here to be non-subscribers to workers' compensation insurance. Obviously, from a company standpoint, that can save you money on insurance premiums and getting policies, but we don't see it very often, just because the risk that a company takes it being a non-subscriber is that they are opening their company up to liability for their own negligence. And so I think maybe one of two states that still have this. Oklahoma is in the transition. They used to be the other state, but I think they've moved away from allowing that non-subscriber, and we're kind of one of the last ones here. We just don't see many companies who do the non-subscriber wise, just because the risk of opening themselves up to liability is very high, right? The whole point of the workers' compensation is to make sure the employers are covered and to insulate the employers from that potential liability.
Right. For those who don't handle a ton of work comp, I mean, the general idea is it's like the great compromise in a way where, the government came in and said, hey, employers, you are going to be responsible regardless of fault for covering injuries to your employees while on the job. But in exchange, that is going to be what they call it, the exclusive remedy, right? Your exclusive remedy is through workers' compensation. You can't then collect work comp and then also sue your employer for their negligence and recover in a tort claim, whatever other kind of claim. So that's kind of what you're saying, Mark, is in Texas with the non-subscribers, if they do sign up to be a Texas non-subscriber, then they have exposure for basic tort liability, correct?
For their own negligence of the employer, they can be sued for that. Versus if they are a subscriber to workers' compensation in Texas, that liability is prevented by being a subscriber to workers' compensation.
Okay. And do you see a lot of non-subscriber work, or is this primarily, that stuff that they're, it's over here and then you're handling the insured work comp, like standard comp Subro on your side?
Yeah, we just don't see a lot of the non-subscriber just because if an employer is a non-subscriber, it's up to them to provide their own benefits. And we just don't come across any companies that we deal with or represent that deal with that. I mean, I'd say it's probably 99.9% of employers go ahead and get that workers' compensation coverage. It's rare, if ever, that you see a company that is a non-subscriber. But again, it is an option here in Texas, one of the last few states in the entire country where that's optional.
Okay. No, that makes sense. Now, obviously, we're talking then going forward today of understanding for the audience that are non-subscribers, that's what that means. But talking going forward, these are going to be, you could say, subscribers or like true insured employers, not non-subscribers. So in that situation, tell me a bit about, what any unique factors that come into play with the pursuit of these cases.
One unique factor, and you see this in a lot of states, is that the employer or the insurance company for the employer, I should clarify that, has the right and the ability to file the suit against the third party tort fee. Whether or not the employee participates or not, the employer and the insurance company can take the lead in filing suit against that tortfeasor to recover the money that was paid out for a compensable injury. And so there are a lot of states we handle where, the timeline changes, or states where, even uniquely that the employer cannot pursue the claim on themselves. And I'm saying employer, I mean the insurance carrier for the employer, such as New Mexico. We handle a lot of New Mexico losses in New Mexico. You're at the mercy of the injured worker. So if the injured worker decides in New Mexico they don't want to pursue a claim, the carrier is left hanging or holding the bag in terms of no recovery. Whereas in Texas, the carrier can take the lead from day one of the injury, get out the demand, see if there's a denial, and make the decision to file that suit as soon as they feel like it's necessary to do so.
And that can be a huge factor. Whenever I train clients in workers' compensation subrogation, one of the first things that those that are new to it think is, oh, wow, work comp Subro, we just send a letter. Okay, then we send another letter and we say, hey, please protect our lien. And then we trust the plaintiff's attorney to protect our lien. And I hear about this process. I'm like, well, you know what? I did this for a big group of people at NASP maybe 2 years ago. And I said, hey, everyone in the audience, raise your hand if you trust plaintiff's attorneys. And not one person of about 150 raised their hands. And no surprise, given the insurance crowd. But then I also asked the next question, raise your hand if your first thing you do on any work comp subrogation matter is just ask plaintiff's attorney to protect your lien. And then you just sit back. And at least half the audience raised their hand. And then we went into the details of being like, well, that's not what work comp subrogation is. We need to be prepared to take active, aggressive roles. In states like Texas, as Mark just said, you just mentioned just now, I mean, you can pursue this independently. You can pursue on behalf of the carrier. And if we're doing that, that means we need to be prepared to do so because the comp carrier becomes aware of these claims months, if not years even, before that injured party retains counsel, starts investigating. So if you have a product-related injury, if you have a complex accident where you need a reconstructionist to go to the scene, that plaintiff's attorney is not going to be able to do it in the future. So that justifies really prompt and aggressive action for the comp carrier because they have to embrace that unique position. I tell all my clients, embrace the position you're in. You are aware of a viable claim against a third party way before the injured party is ever going to be talking about bringing that claim. So preserve evidence, move forward. And now, Mark, in Texas, you have the right to pursue in the name of the carrier. If you do so, I mean, are you pursuing just the damages for the carrier, or are there times where you're actually pursuing via pain and suffering or any of the damages for the injured worker as well?
The majority of the time, it's just on behalf of the carrier. There have been instances where we will sign up an injured worker who maybe doesn't want to hire their own attorney, maybe thinks that attorney is going to charge them too much money on a contingency fee. Some of these attorneys are charging 40% now. I've seen in California, there are attorneys charging 50% contingency fees on personal injury claims now, which to me seems borderline unethical. That's just my professional opinion. But, we always, one of the first calls my office and what I've trained my folks to do is call the injured worker and develop a relationship with them. Let them know who you are. Let them know that you're on their side and that we're working hopefully together to get that recovery. And they may decide not to retain counsel at that point and either allow us to give a referral to trusted injury counsel that we use. There's maybe 2 firms in Texas that I trust to send the work to that we work well together with and refer them files because I know they're going to do a good job and not cut out the carrier and make sure that all these settlements are fair and equitable. Or if not, many times the injured worker will say, hey, I've got this claim. It's not major, but I'd like some assistance. And we enter into a joint prosecution agreement with them to garner their cooperation and to help them get a recovery and save some money on the fees so that they're maximized in terms of their recovery for the third-party tort claim.
And in the audience of this should know that you need to be very careful with joint prosecution agreements because every state differs on when it's ethical, what conflicts can and cannot be waived, and so forth. But in some states where there's a very ironed out, spelled out allocation formula, you can appropriately enter a JPA in situations where it's warranted. We'll look into situations like that sometimes where, I've had scenarios where we have a slip and fall, marginal dollar value of $50,000 to $75,000 in benefits paid, where the carrier alone, it's not going to be economically viable to pursue. But by teaming up together, right, or even for the claimant, they could get an attorney. They reached out to a dozen attorneys. They couldn't find an attorney because that attorney knows that the comp carrier is going to get a large portion of that lien. So there are scenarios where we actually really do like a slip and fall. You need claimant's input. You can't just rely on, the facts of the case. You need to know exactly what they were doing at the time, what training they had, were they wearing appropriate boots and footwear. So a lot of stuff. So that is definitely a creative option and something that, it sounds like you don't do often down there, but it is an option if that's kind of the only option.
Yeah. And to kind of follow up on that point is we see many times where, we'll have a sizable workers' compensation lien and the injury counsel realizes quickly that maybe the other side, if we're talking about maybe a motor vehicle accident, and they don't have sufficient limits to even cover the lien. I've had plenty of cases where the injury counsel drops the injured worker as a client and just leaves them there stranded. And so part of the time to garner some of the cooperation with the injured worker is sometimes, we'll cut a deal out that the injured worker gets some sort of recovery from that for their cooperation. And we split that fee with them versus the work comp carrier taking that first dollar, which we are statutorily entitled to get. But pretty hard to get the cooperation of an injured worker who just lost their plaintiff's attorney and realizes that they're going to have no recovery because there's a limits issue. So sometimes it's worth the piece to try to get them to participate, right? Kind of catch more bees with honey than anything else. So there are ways to get people to work. And, that situation we come up with a lot is, let's say the injured worker's no longer with that employer. They don't really care what happens to their former employer's insurance policy. They're just bitter because now there's not enough money to go around. Well, if we can cut them in for a little bit and get a deal with the carrier of their injured worker, they're much more apt to, show up to depositions and trials and help out and get those photos of the incident scene and really walk through what happened on the loss. So there's a lot of different ways to approach these to maximize the recoveries for our clients.
Absolutely. So now, just to get back that allocation formula, because that's usually the big thing for comp subrogation. Of course, what money does the carrier actually get back in their pocket? So Texas, the first money, the first money, right? It's not, Wisconsin, for example, has the 10229 formula, where a third plaintiff's attorney gets paid first, third goes to the injured worker, the remainder goes to the carrier up to the point of their lien, at which the remainder is a credit. That's a different formula. So you'd say in Texas, it's just first money goes back to the carrier. Is that right?
Well, yes, with an asterisk. So yes, the carrier is the one prosecuting the claim. The carrier gets the first dollar out of any settlement, judgment, et cetera, that resolves that claim. Now, if the injured worker has independent counsel and they filed a suit and we intervene, which we'll talk about later, is my recommendation to intervene every single time, is now becomes a net recovery out of the money in terms of the carrier's reimbursement. So the attorney's fees and the costs come off the top, and that becomes your net recovery, and the subrogation lien attaches again to that net recovery. So there's two different ways of looking at it. It all depends on if the carrier is the one instituting the suit and kind of driving the bus here, or if it's personal injury counsel who's doing the same. And so it's very important to know that distinction so that when you go to calculate the reimbursement for the carrier and for our clients, that we can explain to them clearly what pot of money this is going to get pulled from.
In many claims, it's not just the amount that was paid, right? This is kind of where there's a disconnect, a lot of times actually between work comp defense attorneys and work comp Subro attorneys, which is why one of the best recommendations I have, and it sounds self-serving, but frankly, who cares? It's the right decision, is to never use work comp defense attorneys for the handling of subrogation claims for work comp Subro. You say, why is that? These attorneys specialize in workers' compensation. Well, there's a bunch of reasons. Number one reason in my mind is that work comp applicants' work doesn't even work in the same civil construct in most states, meaning that work comp defense attorneys are dealing with most states, ALJs, administrative law judges. They're going to hearings with different evidentiary standards, and they're not dealing with third-party tort claims, meaning that attorney, the majority of them, they probably know enough to be dangerous, but they're not experts in telling you, what's this case worth? What do we think? If you ask me, if you give me an hour to look at a fact pattern in a case, I can give you with a relatively decent degree of certainty, not certainty, but a decent estimation as to what that third-party claim is going to resolve for within a reasonable range. That's because we deal with this so much. Work comp defense attorneys, that's not what they do. Another main reason, which is kind of leading into my next question for you, Mark, is the future credit. A lot of our clients, we started a new program with some of our big clients. It's kind of like a beta version. What we're doing is anytime a work comp carrier wants to waive their lien, right? Where there's a third party claim going. There's also the first party claim. They're trying to get to full and final, resolve that the top claim. Work comp defense attorney says, yeah, let's resolve the lien. I have to come in, or one of my attorneys, and we have Subro counsel, client, and work comp defense counsel get on a call. And they talk the facts, we review, and we both give our own recommendation. And if we can't agree, then we kind of come together and try to find a solution. I can't tell you, at least half of the times we have those calls where a work comp defense attorney is adamant. Yep, we need to waive Subro, waive the lien to full final it out. We look at it, we're like, hey, I get what you're doing, but you're wrong, right? We're going to recover, it's going to be $250 on the third party claim. We're going to get at least $250 of that. We're going to get 2/3, and your full value, even based on kind of inflated reserves and futures, is going to be $100,000. So, okay, 2/3 of $250 or $100,000 that may be saved. Yeah, I'm taking the 2/3 of $250. And a lot of times that happens. Like that's a big factor. But Mark, walk me through that important thing, the idea of a future credit in the comp. Tell us a bit about what it is and whether we have the right to also assert and have a holiday or credit when that third party claim is settled as well.
Yeah. So once the third party claim is resolved and the work comp carrier is paid back, anything over and above what the carrier is paid back operates as a future credit up until that full amount. So let's just say $100,000 settlement, 50 grand goes back to the carrier. We have $50,000 in future credit there and future benefits that the carrier is not going to have to pay out until such time as the injured worker can prove up the medical bills and lost wages that equal that now $50,000. So it's very important to document that credit and to make sure it's there. I'm in complete agreement with you that I don't like when the work comp defense says, let's waive Subro, waive future credit, because simply every dollar that the carrier pays out gets added to the lien in terms of the reimbursement. And so waiving that claim is really shooting yourself in the foot, in my opinion, because once any recovery occurs, basically waiving that claim is losing money every time you do that. For every dollar that gets paid out, it adds to your lien. And that's one more dollar that the settlement has to reimburse the carrier for in the event the case is eventually resolved.
Absolutely. Now, going on from that in the future credit is you briefly discussed the idea of intervention. I think this has been one of the biggest sticking points, right? Between kind of the carrier, the TPA, there's a lot of adjusters or people that work for third-party administrators that listen to the podcast, the Subro vendor, and the law firm. And it's the idea of, should we be intervening in a lawsuit, right? For those who don't know the kind of the litigation process, plaintiff's attorney files suit, we become aware of that lawsuit. Do we then hire counsel to intervene in the litigation, where we either take an active role or we sometimes just sit back, make sure our claim's protected, respond to discovery as necessary, and just make sure we're not settled around. Now, every state totally differs on how, why, whether, where, and when we are going to intervene and take legal action. Some examples, Wisconsin, interestingly, we're named an involuntary plaintiff, so we have to file an answer on behalf of the carrier. So we have to be a party to the action. Other states, Louisiana, if we don't intervene, we can just outright lose our right to our claim. It can just be barred. Another state example, California, which we deal with a ton of, you don't have to intervene, but if you don't, plaintiff's counsel and defense counsel, they know about it. So they just end up coming to get together in a room. And when they know it's too late for you to make your case, they're just going to settle around you and leave you holding the bag. Every state differs on how the settlement can be gerrymandered and, frankly, what plaintiff's attorneys can do to just screw over the carrier however they want to. Tell me a bit about Texas. Like, what is your recommendation? Is intervention recommended? Do you have kind of a standard process for doing so? Tell me a bit about that.
My recommendation is always intervene to protect the client. Talking back on that example I gave earlier, where maybe we learned that there's not enough limits to cover a claim, right? If we're not intervened and suit's been filed and statute runs and the injury counsel says, hey, there's not enough limits, this isn't worth my time, and they dismiss the suit, if the statute is run, the carrier is now left with 0% chance of recovery because we weren't a party to the suit before it was dismissed. So at a minimum, the intervention protects the statute in the event the plaintiff's attorney does something such as withdraw or dismisses the case. And then the statutory part of the labor code says, yes, it's first dollar, it's a statutory lien. Well, that's fine and good and all, but if a case gets settled and we have intervened and the injury attorney distributes that money to the injured worker, that money's going to be gone. There's not going to be much chance of recovery from that person, right? People take those, they pay off loans, they pay off bills, they buy themselves a new car, whatever it may be. My experience is once that money hits the bank, that money's pretty much going to be as good as gone, right? Whether they're paying for their kids' college or, like I said, a new car or a boat or whatever they do with that money, it's going to be a lot harder to get that back from them versus once you've intervened and that money hits. Well, now you can make the argument that, hey, the attorney's on notice and the attorney now is on the hook for reimbursing the carrier for the claim because they had actual knowledge that the lien was out there and they didn't comply with the statutory requirements of 417 of Texas Labor Code. So it is always my suggestion to intervene, make yourself a party to the suit, protect the interests, and make sure that you're there and actively participating. And a lot of times we see on maybe smaller claims, these plaintiffs' attorneys, all the billboard guys, they want that big $10 million crazy hit. Well, not every case is $10 million. So some of the smaller ones, they may not be driving the ship. Well, as a carrier, if we've got a smaller one, I'm going to push that case, right? I'm going to continue to push it toward a trial date, mediation settings, getting depositions done so that the case stays active and eventually gets resolved versus just sitting there kind of stagnant in the courts for 2 or 3 years. So these, smaller $50,000 to $200,000 cases, we want to be driving the ship and pushing the case forward, and our intervention helps do that.
Yeah, I mean, that is a unique factor that is really not talked about enough. And it's the idea that not only are we intervening to protect the client from the settlement being gerrymandered or for it just to be distributed and nothing come back, but we can also add some pretty significant value. I've won in numbers. I think it's in Utah. Big product liability case. It's about a $750,000 paid in work comp Subro. And the plaintiff's firm is one of those sign and settle, 1-800 law firms who only handle auto cases. This is a complex products case. And I talked to the lawyer and just to say, hey, tell me about what's going on. Are you going to file a suit? If so, we'll intervene and move forward. And he's pretty much says to me, do you do any products work? You're like, yeah, we actually do quite a bit of it. We have a whole products liability, vertical in our firm. It's like, oh, well, I've never handled the products cases before and nobody else has. And, I don't really know what to do. Can you help me? And I did face palm a little bit. But in the end, I'm like, hey, I'm going to create a great relationship. And guess what? He's not going to come back and try to mess with my settlement in the end. So sure. And now in that case, I'm taking an active role, right? I am actively helping him build up the case to increase the pot so that we get more money back. But there is something to be said, and you did briefly mention that, Mark, about us not just being there to take a passive role, even when we're in litigation, we have intervened, but we're also oftentimes actively participating, pushing it forward. I think it's a very good point to make.
And with that active role, we can prevent some of the attorney's fees from being paid out to injury counsel. So a court can look at this and have a hearing, and they will apportion the 1/3 fees that's available under the labor code based on the participation and the activeness of each side. So the work comp subrogation counsel, if we're involved and we're in depositions and we're at hearings and we're helping with witnesses and we can do all that, we can now get the argument that says, hey, we're active in this case. They're not entitled to a full third fee on this and save the carrier some money. And then also, and this is a major one, this is going to really help out on big complex injury cases. Once a carrier is involved in Texas and they intervene into the suit, the carrier no longer owes a fair share of cost. Now, not fees. We're still going to owe some attorney's fees, but we're not going to owe the cost. And I've had that battle with injury counsel time and time again who aren't familiar with the labor code and don't read it. But the portion of the labor code that deals with once a carrier is intervened does not allow for costs to come off the top. So we can save a lot of money just by intervening in just on the case costs alone. And the other tip for intervening that we use a lot, and I've used this on the doorstep of trial, is negotiating a lower fee with the injury counsel and getting a joint agreement on the record with the court where both plaintiff and defense will stipulate to the amount of the work comp lien. And for the plaintiff, they like that because now the jury doesn't hear that there's insurance involved. And the defense likes that because now the amount of damages is not inflated. So it's a win-win for the carrier in terms of reducing those attorney's fees. The plaintiff doesn't get the insurance in front of the jury and the defense doesn't have an increased amount of damages that the jury's hearing. So I've not once proposed that and had anybody deny that request simply because it both sides win and come out ahead when that occurs.
And those are those kind of soft skills, like that knowledge that you just have to pursue these cases effectively, right? That would be something where if you just have somebody who's never handled work comp Subro in Texas and like, oh yeah, we handle uninsured debt collection and auto work. And then we'd love to litigate your, work comp Subro. I mean, it just shows how complex this is, right? Being able to come up with those creative solutions, knowing we need to intervene to get to that point. But once we have that leverage, we might as well come up with potentially a mutually beneficial approach where we get something guaranteed, something very significant, but we don't have to have the jury be able to see the involvement of that comp carrier. That's basically what you're saying, right?
Yeah, that's exactly right. And one thing that came to mind, we talked about we're talking about attorney's fees and the future credit is attorney's fees are not owed on the future credit. So once that settlement gets done and everyone's been paid out, when we assert that future credit, they don't get to reduce by fees and costs anymore. That's a whole dollar number. And we always want to make sure that future credit is documented or it can be waived. So there's a form called a PLN-09 that once a settlement is there, you file that with the Texas Workers' Compensation Commission, and now you've got the lien written into the record, right? The future credit filed with the Work Comp Commission, with the state agency, and everyone knows it. So other times, we'll have injury counsel who wants to keep the settlement confidential. Well, we've had hearings where they have to go disclose it to the Work Comp Commission because if they don't, we can't accurately waive our future credit or assert our future credit. I've had attorneys who don't want to do that, and they've said, we'll get something on the record that says you are entitled to unlimited future credit if you make us not disclose what the settlement is. And that's fine with us because for our clients, they now can say, regardless of how much money ever gets paid out or they incur medical bills in the future, the carrier is off the hook and they can close that file. So there's a lot of ways to utilize the tools and the labor code to our advantage and our experience to make sure we're protecting our clients' best interests on everything, fees, costs, and future credit.
So two important takeaways from that, I think, for the audience. One would be that in Texas, we actually should be filing this with the commission. Is that correct? That there's a formal procedure? Because I see this all the time where, frankly, some Subro vendors handling the work comp, pretending to be experts in everything. Next thing you know, they sell and they got a credit on it, but it was never recorded. And then they're getting in trouble, right? So this should be recorded with the commission. Is that correct?
Required. If you don't record it, it can be waived. So it's not a should, it's a shall. It needs to be documented. And that's something that we preach to our clients. And once we get that settlement, we've got the numbers done, I keep the link to that form and I send it to them and say, get this on file today.
And another thing to note there is just the importance of the credit. I think that future credits are given way too little weight by a lot of insurance carriers, a lot of vendors, a lot of companies who do this work. Frankly, because I want to get the money today, right? You don't see this benefit until years later. So they're sitting there just saying, I could get $60,000 today, or I could get $75,000 if we waive the future credit without even thinking about the fact that it's $15,000 more, it's $15,000 delta, but the future credit would have likely had a value of $150K, something like that. So future credits, we just need to remember the back of our mind that we need to review every case independently, look at what the futures are set at, what we truly expect treatment to be, and come to terms with that. Because it happens very, very often where plaintiff's counsel is going to ask for, waiver of the future credit contingent on resolution of that claim, especially when limits are an issue or there's anything like that. So really having a strong understanding of what that future credit is, also referred to as a cushion or a holiday, and just knowing kind of how to evaluate those things to figure out, is this an absolutely never waive scenario? Or is this one where, sure, if we're going to, we still just need to put a dollar value on it to be able to assess?
Completely agree. And again, documenting that credit is one of the most important things a carrier can do, especially if there's a significant settlement.
Now, before we move on to some of like miscellaneous things I want to talk about, one more thing on intervention. A lot of other states, there's numerous other ways to gerrymander settlement. A lot of the East Coast states, there's a way that plaintiff's attorney can argue that, the settlement was 2/3 for not economic damages, for pain and suffering. And the lien only extends to the economic damages. So your lien has to be reduced initially out of the gate by 2/3. You're only taking 1/3 and then you're negotiating from there. Other states, they can just settle around you. Other states, many states, Wisconsin, for example, we have a very pure allocation formula, but there's also a way to allocate part of that to loss of consortium, to a spousal claim, meaning that in Wisconsin, I had one just 2 months ago where plaintiff's attorney came forward on a very marginal injury, and they claimed the spouse had 50%. 50% was going to loss of consortium. It's like, absolutely not, right? We'll take that to a Ryan's hearing, take it to a hearing if we need to. So when it comes forward, I mean, do you have any other unique scenarios like that where settlement can be gerrymandered, or is it pretty much we're looking at those other factors such as, making sure that it's not just distributed without, permission, making sure that, we're limiting our costs and fee exposure?
Yeah, absolutely. It's first dollar. So whatever money's recovered, it's there. We've fought the fight many times where maybe an employee's spouse is a named plaintiff, and they try to say, well, all this money isn't for any of the injuries, any of the lost wages, any of the pain and suffering. It's all loss of consortium. Well, we'll set that for hearing with the court and argue that there's no way the spouse is the only one recovering for loss of consortium when the person who was injured is the actual plaintiff at this, right? They bring in the spouse to try to gerrymander that around, but we fight that fight many times and we're successful on that every time in terms of letting the court look at, what the actual damages are to the injured person and not the spouse. But so that statutory scheme is the first dollar, and we enforce that time and time again.
So for the audience, if you're looking for another resource on whether you should be intervening, we did just revamp our chart on the website, mwl-law.com. And it does have now, do you need to intervene? ? With either no, yes, maybe, recommended, and so forth. So super helpful. It depends on the facts, the fact patterns of the case. But Texas, Mark is saying, you can refer back, Mark say, just intervene in the case, avoid the headache. All right. Some miscellaneous things I want to touch on. Every state differs as to whether we can recover from underinsured or uninsured motorist benefits. In Texas, Mark, can we recover our work comp subrogation lien against those benefits?
Only if the UIM policy was purchased by the employer. We don't have any right of recovery from the employee's personal policy if something is paid out under there. But if the employer took out a UIM policy and benefits are paid under that, the work comp can attach that lien to those benefits as well. And so, in that situation, we discussed where maybe the tortfeasor has a minimum limits policy and the employer had a UIM policy in place. That policy can be subrogated against by the work comp carrier, and we get our reimbursement from that money. So Texas is very business first in terms of allowing insurers to get that money back first dollar. And the reason being is that it's encouraging employers to continue to get these policies because as the insurers recover, helps keeps premiums lower, and encourages employers to come in and provide that workers' compensation insurance in that state. Complete opposite of what I see. I'm licensed in Georgia, and Georgia has a very, very strong, probably the strongest in the country, made whole doctrine on workers' compensation. And every plaintiff's attorney knows this, and they are going to assert made whole every single time. So it's very rare on a Georgia work comp subro that we recover, simply because that made whole doctrine is so strong that it can't be overcome. Now, of course, there's some one-offs here and there, but the end result is talk to a lot of clients and insurers who say, we just don't want to write business in Georgia anymore because no matter what, we can never recover for the case. If the third-party tortfeasor rear ends somebody and the claim gets paid, the carrier is left holding the bag with no right of recovery ever. It doesn't matter how low or serious the injuries are in Georgia. Made whole doctrine defeats 99.9% of every workers' compensation subro claim that we see. And so, the net result of this first dollar and not having made whole is that it's encouraging insurers to continue to provide coverage for Texas-based employers so that employees are covered and that, there's a fairness to the system that when they pay, under the workers' compensation policy, if someone else is at fault, they can recover in the subrogation and keep their books on par with what they're supposed to be. It's just not money going out the door on accidents where there's a tortfeasor responsible for those damages.
Georgia is awful, right? I mean, I like the state. My wife works for Delta, so I fly through the airport all the time. It's like anytime you have a flight anywhere, you could be going from, Seattle to Los Angeles, they're going to stop in Atlanta along the way. Not actually, but, I'm there often. But when it comes to Georgia, though, I mean, the other funny thing, not that this is a Georgia podcast, is that, but if benefits aren't paid in Georgia, you have zero right to subrogate for a Georgia accident, which is kind of fascinating. It's like, you don't want to write in Georgia, but if you're going to have any claim in Georgia, you better make sure those benefits are paid in Georgia, or else there's no right to subrogation.
Yeah. Well, we can do the Georgia podcast right now. There's no right of recovery in Georgia for workers' comp. End of podcast.
It's pretty much, that we've been sending, Garrett Wickett's been sending the state legislature email, like all kinds of the different individuals in the legislature emails every year. Like, your system's idiotic. Stop doing it. You're destroying the work comp industry in your state. Nobody wants to be there. And it hasn't gone anywhere, but you never know. Maybe one day they'll just respond and be like, we agree. Probably not. All right. I guess the last question regarding kind of work comp, Subro, that I wanted to ask you is that as it relates to, states differ as to how employer negligence impacts the work comp recovery. So there's certain set cases, scenarios where, the employer is partially responsible for the condition that caused the injury. How does that apply in Texas? Does it reduce the claim? Does it have any impact?
So the lien is reduced by the amount of the employer's negligence. But the nuance to that is that only counts for a judgment. So if we're negotiating a claim and the injury counsel, says, well, the employer's at fault for that, that's fine, but they can't prove it. There's no way to set that for a hearing. No court's going to hear that. It's only a trier of fact on a judgment that will reduce the employer's negligence. So if they want to settle, they cannot make the argument of employer negligence because there's no way to prove it. The commission's not going to set a hearing on it. A judge is not allowed to have a hearing on it to apportion damages. It's got to be the trier of fact at a trial on a verdict that awards, the percentage of fault to the employer. Anything outside of a verdict sheet filled out is a non-starter in terms of negotiations.
Absolutely. So all in all, intervene in Texas, but I guess that's even another reason to intervene, that if there's ever any allegation of any possible employer fault, you definitely want to be in that lawsuit.
Correct. Yeah, that's my recommendation is make yourself a party to the lawsuit every time if possible. It's pardon the pun, an insurance policy for the insurers to make sure that lien is properly addressed and paid back in accordance with, the controlling state law.
Excellent. All right. Well, that's all my questions. I mean, do you have anything else you wanted to add that the audience should take away today, aside from, make sure to call Mark Solomon if you're ever looking for a Texas Work Comp Subrogation Counsel?
No, I was going to self-promote myself that and say, obviously we're available on our website and my email and phone number. If you've ever got a question and you need something clarified, shoot me an email or give me a call and we'll talk through it and try to figure out the best way to make sure that we're maximizing the recoveries for our clients.
Excellent. Well, Mark, thank you so much. Audience, I appreciate everybody. Until the novelty of this wears out on me, I did do another song on Suno to do for the closing. As I think I mentioned, I'm not sponsored by them at all. I mean, maybe they'll reach out one day, but I just love the AI technology and it's kind of funny to listen to these songs. So we are going to listen to, as we close out, Subrogation in the Lone Star State. Thank you everyone for joining, and signing off. This is Ashton Kirsch with the Subrogation Support Network podcast.
Somewhere between the courthouse and a honky-tonk, there's a man who wears a Stetson and a fancy pair of snakeskin boots. His name is Mark Solomon, the finest in subrogation for a company called MWL Law. There's a lot of folks who don't know what subrogation means. It's when an insurance company pays you when it's not their fault, and they hire someone like Mark to go get it back. And the Lone Star State is the best place to do that. It's subrogation in the Lone Star State, and if you don't like it, well, you're a little late. He makes first dollar every